I'm Michael Kirby, and I'm speaking to you from my chambers in Sydney, Australia. Exactly opposite my chambers is the Parliament of New South Wales, established in colonial times and still operating, and as I speak to you, Parliament is sitting, the flag is flying. Down the street, to my right, is the Supreme Court and the Federal Court and the courthouses where justice is independently dispensed, not dispensed of, but given freely to the people, if they can afford to get into the courthouse. To my left, down the road, is Government House. Government House is the residence of the Governor, the representative of the Queen in New South Wales, and across the harbour is Admiralty House, where the Governor-General, when in Sydney, stays. And all around us is the executive government in the offices in the Sydney CBD. So I'm here to talk about the separation of powers, the separation of governmental powers. Of course, there are many other powers in the state and in the land. The power of the churches, the power of the universities, and especially nowadays the power of corporations, of business, including multilateral, multinational corporations with very large amounts of money at their disposal, sometimes amounts greater even than the money available to the executive government and the Parliament in this country. The secret of ensuring democratic, fair and rule of law societies is said to lie in dividing power and separating it from the different branches of government. Why should that be so? The idea behind the separation of powers is that if you put too much power in the hands of one person, that's dangerous. That person might get carried away with their power. They might think that they rule the world and certainly rule the society, and separating power and dividing up power in a society is thought to be better for the good governance of the people of that society. Now, I am really relieved of a lot of the work I otherwise would have had to do by the publication of the Parliamentarian in an issue in 2016. And this issue contained a record of speeches that have been made recently concerning the separation of powers in many jurisdictions of the Commonwealth of Nations. That great international family, rooted in history but preserved because of its utility to us all, to respect each other and respect diversity, but to learn from each other and the ways in which we go about things so that we won't repeat the mistakes of each other, but will learn from experience and ultimately get governance right for the benefit of the people whom we serve. No one, judge, governor, member of Parliament, member of the executive, member of the great corporations, universities, churches, no one is above the law. All of us work under the law, and the law divides up great power, and it does it for a very good reason, that dividing power makes sure that people keep to the rules and that they don't get too carried away with their own importance. We all serve. Now, this idea of the separation of powers didn't come naturally to the English, and in fact they tended to mix power up so that it did tend to concentrate an awful lot. And in fact, Walter Bagehot in the 19th century said that this was the efficient principle of combining power together. combining the power so that the one person in the English government of that time could be both a member of the judiciary, a member of the executive government, and a member of Parliament. All three branches were symbolised in the Lord Chancellor. And the Lord Chancellor held his office, and it was always a man in the old days, from the times of the Norman kings, one of the oldest offices of state. The Lord Chancellor had all the powers of all the branches in his hands under the king. But as time went by, people thought that wasn't such a great idea as a matter of principle. And in fact, it was one of the reasons for the American Revolution of 1776. The poor Americans, having their revolution, sought to ensure that in the American settlements they would have the benefit of the principles of English government, but that it would be improved by sticking to a few principles more closely than the English had done. And so they insisted on the separation of powers. They thought there was far too much power in the hands of the king, who, though a member of Parliament, didn't sit in Parliament, and who concentrated the cabinet and the people who advised him in his own person. And they thought that just wasn't good enough in the American settlements and it should be divided. And so the American Constitution divided power up, and it did so by imposing in the structure and the language of the Constitution the principle of the separation of powers, very strict separation of powers, no mixing up of the power of the executive and the legislature, no mixing up the power of the president and the judiciary, or the executive government and the judiciary. A strict separation of all of the branches. The English learned from the American Revolution, and in fact after that revolution, during the 19th century, there evolved the English system of government which most countries of the Commonwealth of Nations have followed. The executive, notionally the king, sat in Parliament, and Parliament elected the executive, and the executive was the government that made most of the laws. Parliament enacted the laws, but generally it did so on the behest of the executive government sitting on the benches in Parliament. And so that meant that the strictness of the separation that exists in the United States was broken down. In the United States, the executive government does not sit in Parliament. The executive government is out of Parliament, and the President works in the White House down the road from the Congress. And we've seen what that means. We've seen in practice the rigidities that too much separation can cause, at least in the relationship between the executive and the legislature. President Obama had the power under the American Constitution to nominate the judges, just as in most of our countries the executive does that, either in practice fully or formally and with the advice of others. But in the case of the United States, President Obama sent a nomination to the Congress, to the Senate, for confirmation, and they simply ignored that and did not proceed with the nomination of Judge Garland. And so now, at the moment that I'm speaking, there is a nomination by President Trump before the Senate of the United States, and that is being considered now. But the important point is the separation is quite strict, and it is symbolised by the strictness in the United States of America, which is much more rigid than in Commonwealth countries, or at least most Commonwealth countries, and in particular those that follow the Westminster or Parliamentary tradition. Now this means that in our countries the executive sits in the legislature, and therefore a strict separation is not possible. Indeed, the strictness of the separation that the Americans insist upon is something that really is not attained in most Commonwealth countries. It's certainly not attained in the division of responsibilities between the legislature and the executive. Aristotle said you have to divide power. Montesquieu affirmed that, and the Americans followed it up with great vigour. But we in Commonwealth countries have tended to be much more nuanced in our separation of powers doctrines, and strict rigidity has been rejected in many instances. But just the same, in the relationship between the executive and the legislature, you do get instances in Commonwealth countries in which the executive endeavours to control the legislature but fails. And in those circumstances, it's necessary to apply the words and the doctrine of the constitution of each individual country. In a bicameral system of government, which exists in most Commonwealth countries and in all jurisdictions in Australia except in Queensland, the state of Queensland, and also the legislature in the Northern Territory of Australia and the Australian Capital Territory, is unicameral. But in other jurisdictions of Australia, it's bicameral. And because of the different electoral systems, you get in those jurisdictions which are bicameral quite often a difference between who controls, which parties control the upper house and which parties control the lower house. By control I mean which parties have a majority in the upper house and the lower house, and the government is conventionally formed by the party that has a majority in the lower house, the People's House of Parliament. The House of Commons in England and in the United Kingdom and in Canada, the House of Representatives, as it's called in the United States, but also in Australia. Because it often happens that in the wisdom of the people, the government controls the lower house but doesn't control the upper house, you have a tension between the position of the government and the position of the legislature. The government may wish to get its legislation through Parliament, and that will require having an affirmative vote in the upper house, but it may not control the upper house, and indeed the upper house may be made up of members of the opposition party and independents, as is the case at the moment in the Australian Federal Parliament. We had a commitment by the Government of Australia, which was returned at the last federal election, to conduct a plebiscite on the issue of whether Parliament should enact legislation to recognise same-sex relationships, marriage equality. This is something which has been enacted in many countries, including some Commonwealth countries, the United Kingdom, Canada, New Zealand, but it hasn't yet been enacted in Australia. The government was committed to having a plebiscite, but in the upper house, the Senate, the majority of senators were not in favour of that. They said it would be very divisive. It would lead to a popular campaign which would denigrate gay citizens, and they didn't like it, and they thought it was political, and they should vote against it. So they did vote against it. Now that is an instance of the separation of the legislature from the executive. It is not inconsistent with the principle of the separation of powers. It's the very essence of the separation of powers as found under the Australian Constitution. There have been other instances where the legislature and the executive have sometimes been in disagreement. Generally speaking, because the executive government will have a majority, certainly in the lower house, and when it loses that majority, it will generally lose government. The division is easily respected. But sometimes, because of the importance of the power of Parliament in our system of government to control the spending of the people's money, the money raised from the taxpayers, the citizens, and others living under the protection of the law in the country. Because of that principle, you sometimes get questions as to whether the rule that the people's money is to be spent in accordance with legislation enacted by the lower house has been properly carried out. We had a case on this question in the High Court of Australia, Australia's Federal Supreme Court, when I was a justice of that court. It concerned the issue of whether legislation had been enacted that permitted the government to spend very large sums of money on advertisements, allegedly informative advertisements, in favour of legislation it had introduced into the Parliament to promote its industrial relations policy. The legislation which was passed by the Parliament had provided for the spending of the people's money on better and fairer workplaces. And the question was, did a provision in those general terms permit the Parliament, under the terms of the Australian Constitution, to spend money on a big advertising campaign for millions of dollars to promote an understanding of and popular support for the then government's, the Howard government's legislation on industrial relations. That issue came to the High Court of Australia, and the High Court, as was often the case in terms of constitutional challenges, was divided. The majority said, yes, better and fairer workplaces is a reasonable way to describe the legislation which is before us, and that was enough. A minority in the High Court, including myself and Justice McHugh, said there had to be greater specificity to permit the spending of the people's money in very large sums in favour of promoting its own legislation. And if that could be secured through the Parliament, that would be permitted. But because it hadn't been secured, it wasn't within the appropriations enactments and therefore couldn't be spent on that purpose. That's an indication not of a clash between the principle of Parliament and its great powers, but an upholding of that rule in the Parliament that ensures that the great powers are exercised in a way that is consistent with the popular control, the people's control over the spending of money on the purposes that the people, through Parliament, permit. In Parliament now, in Australia, in many of the legislatures, there are requirements that legislation go through a kind of filter machinery within Parliament in order to consider whether the legislation conforms to the international human rights treaties which Australia has ratified, although not generally brought into operation as part of the law of the land. Some might say that's another instance of the breaking down of the power of Parliament, and it's inconsistent with the separation of powers. However, in my view, that is a fulfilment of the separation of powers. It has been enacted by Parliament to provide this scrutiny and filter, and it's the fulfilment of the requirement that the filter should operate. Now, the differentiation, I think that it's important to keep in mind in countries of the Commonwealth, is a differentiation between the relationship of the executive and the legislature, which is inevitably much closer because the executive sits in Parliament, and between the legislature and the judiciary. The judiciary is outside Parliament, and determinedly so. And keeping the judiciary independent of both the other branches of government is a very important principle which is upheld by the Latimer House guidelines and by the principles in the Commonwealth Charter and by the fundamental principles in the constitutions of most Commonwealth countries. And it is to that issue in the separation of powers that I will revert in my next talk, the separation between the judicial branch of government and both the others, a separation that is essential for upholding the power of the law over even the great powers of Parliament and the executive.